I was pulled over in Amherst, Virginia for not having an inspection sticker on my car. I turned into the public library parking lot and parked in a legal parking space. After being ticketed, I was forced out of my vehicle after already being released from detainment against my consent and under duress. This was done by threat of arrest for obstruction of justice. I was cited for no registration, switched plates, no insurance, and no inspection. I can dive deeper into these alleged violations in another video in my defense, but for now, I'd like to focus on the conduct of these officers, as civil rights violations are much more serious than silly traffic infractions. Here are a few concerns I have pertaining to this situation and a few open questions for the court of public opinion, potentially federal court, where I'll pursue what I believe to be civil rights violations. Can police have a car towed off of public property in Virginia for being unregistered with the state, or should they simply issue a ticket? Do they have discretion to do either or both? Look, even these officers aren't sure, but they're more than willing to take my car and try to teach me a lesson.
Is it, now let me ask you this. I know you already seen it on that roadway.
245.
Yeah, it's on public property now. It don't matter.
245.
I know.
Call them on. Can you run the tag that you were given and just attach it to the call, please?
I just asked a question.
Does the fact that Dante Robinson asked whether it was legal to do so show malice by these officers due to prior knowledge? If they can tow a car off public property, are they obligated by statute to do so? If they're not obligated by statute, can they still make the claim I am obstructing justice? That would mean they have officer discretion to leave the vehicle there until I have it towed off myself, or until I obtain the proper documentation according to the state. If they have the officer discretion, how can they make the claim I'm obstructing them in their duties when they have the option to simply issue a summons? Of course they were giddy to have my car towed to show me their intent to punish those who dare to exercise their rights within Amherst, Virginia.
Disposition of sold.
Yeah.
Tell them start me a tow truck. Yep. Tell them start me a tow truck.
Huh?
Tell them start me a tow truck, and he's gonna have to call a ride.
Is it, now let me ask you this. I know you already seen it on that roadway.
245 Amherst.
It's on public property now.
245.
He was on the roadway. I can't.
Call them on.
Do you have somebody from that we can ask? Can we leave an unregistered car here?
Call, please.
Just ask a question.
Amherst, next north end.
Can they compel someone to exit their car under threat of arrest for obstruction of justice after releasing detainment? So am I still detained here?
No, you're free to go now.
All right, so I'm free to sit here?
No, you're free to get out of the car so that Martins can tow the car.
Oh, well, if I choose to sit here, I mean, are you going to, like, force me out?
I'm going to arrest you for obstruction of justice, and I don't think all that's necessary.
This obviously doesn't fall under Pennsylvania v. Mims, so what law made up by a tyrant judge are they relying on here? Does Virginia case law Jones v. Commonwealth apply here? To constitute obstruction of an officer in the performance of his duty, there must be acts clearly indicating an intention on the part of the accused to prevent the officer from performing his duty, as to obstruct ordinarily implies opposition or resistance by direct action and forcible or threatened means. It means to obstruct the officer himself, not merely oppose or impede the process for which the officer is armed. If so, compelling me against my will under threat of arrest would certainly qualify as a violation of clearly established rights.
And I agree with you. If you can prove in court that what I've done today is illegal, I want you to, so that I won't do it anymore.
Right. Well, like I said, obstruction of justice requires direct action. I'm putting you on notice. That I'd like to sit here. If you're saying you're going to pull me out of here, then that's another violation of my rights.
Okay. Well, you can't sit in the car while the tow company tows the car.
Well, I'd like to sit here and not move, so.
Okay. Well, again,
You're saying that you'll put me in jail, then I'll just get out. Are you saying that?
I'm saying that if you refuse to get out, I'm going to have to arrest you for
Gotcha.
obstruction. I appreciate that, Mr. Hudson. Thank you.
Wash his hands.
Thanks for stealing my car.
No, sir.
No.
I've already locked it.
Yeah, of course, I do lock. No. I'm allowed.
Can you tow this with the car locked?
This is my vehicle. I can lock the car.
Well, you need to leave
You're
the
telling
keys
me I
with
have
the vehicle.
No, I'm not going to relinquish my keys.
Look, we're not going to argue. If you don't leave the key with the car, it just means that he's going to drag the car on there, which could cause damage to the vehicle. And that's your choice. That is your choice. If you leave the key,
Sir,
you can come pick it up.
You're impeding. Like, I'm trying to shut my door here. This is my property. I'm allowed to lock it up.
Okay.
Am I not?
No.
Robinson?
We're trying to get him to get.
Hey, don't forget your business card to the tow company so you know where to go to get your car, sir.
Without damaging you. We don't.
Did these cops conspire to take my car, force me out in retaliation because I chose to record them and challenge their authority? The excuse he used to tow my car is he can't leave a car parked in a lot without owner permission. Remember, this is the public library. I tried to tell him the library is public, I pay taxes, and the parking lot is just as much mine as anyone else. But I was talked over and railroaded the whole time.
All right, Mr. Hudson. Here, first of all, is a card to Martin's Body Shop. That's who will have the car. All you got to do is provide proper proof of ownership, and you can go pick the car up anytime, okay?
So why are they stealing my car on your behalf?
They're not stealing your car. I'm not stealing your car, but your car was being driven illegally on a state highway in the Commonwealth of Virginia, and for that reason, I must tow it, and I can't leave it parked here in this lot without having owner permission, so I'm towing the car.
Without owner permission?
Yes.
You just stated I was the owner.
Not the owner of the car, but the owner of the property, okay?
I
can't allow you to trespass is what I'm saying.
This is not, you can't trespass on public property.
Now,
this is public property, isn't this? Is the library.
I can't leave this car here.
Can you not interrupt me?
This car away, okay?
At one point, the library director approached and asked the officers, is there anything he could do to help? And Caleb Martin shooed him off immediately.
Library director, is there anything
We're good.
that you need from
Nope,
us? Or?
we're good. We'll be out of here in a minute.
Okay.
Thank you.
Thanks so much.
Yep. Library director. Wanted to know if we needed anything from him.
Supervisor.
Who was that?
Library director.
Being nosy?
Wanted to know if we needed anything from him.
If the excuse for towing the vehicle is they didn't want me to trespass, they had every opportunity to ask the most qualified person there whether my car could be left there in the lot and whether it was considered trespassing. Instead, they chose to assume the library wanted me trespassed and my vehicle towed. There's not a single sign in the parking lot saying no loitering, no trespassing after hours, or anything of the sort. Why did Luther Rose claim he can't allow me to trespass? As many of you know, you can't be trespassed off public property without committing a crime. Why did the Commonwealth's attorney try so hard to prevent me from having these videos?
There is a little bit of dash cam, and there is some body cam, and I believe there may be some ancillary documents. It's nothing groundbreaking. It's just the Commonwealth. They're part of our files, but we don't own those documents. They're owned by the sheriff's office. So, I mean, after the trial is over, they're subject to a FOIA request, and that would be an issue between Mr. Hudson and the sheriff's department. But as of now, we have to shepherd and guard our file. One of the things that we would be asking is, I have no desire to sit there while he does it. I don't want to do that. I would ask that if he had a cell phone or any other possible recording device on him, that it just be turned over to the secretary until such time as he's done viewing the video and looking at the file.
Well, I suspect he preferred leaving the vehicle rather than having her have possession of himself.
I'm sorry. You suspect what?
I I can't imagine you want to hand your cell phone to the secretary. You'd rather leave it in the car than have to deal with that.
Once again, I have no problem in you seeing this. There's nothing I'm trying to hide here. It's not our video, it's not our documents, it belongs to the sheriff's office. So I don't have the authority to turn it over. I can make it available for him to watch, to take notes on, to do what he needs to do with it. And then after the case is concluded, then he can file a FOIA request for the sheriff's office.
I feel it would be better suited in my own environment to actually go through it with basically a fine-tooth comb. I have previously in the past had discovered that there were certain conspiracies to violate my rights, and behind my back on video, he's saying here I can still view it. I don't really I don't agree with it, but and I can agree to not disseminate it on social media or any of that, but ultimately I would like to be able to, in my own environment, be able to go over these.
To this, with the defense attorney, what we often have to do is a situation in which they just, as Mr. Hudson said, wants to view it in a different environment. We've provided in the past to them, but we've provided them with that document that they've signed that they will destroy whatever material that they have been provided once the case concludes. And once again, we have that redress through the state bar for them, but we don't have that for Mr. Hudson.
And it sounds like I'm being unfairly treated because I'm not a member of the Bar Society.
Judge, I'm not asking for anything to prohibit him from doing that. I'm just saying that whatever discovery that the court deems appropriate, that there be in that order statements by the court as to what must be done with it and what can and cannot be done with it.
Say the last part again.
As to what can and can be done with it and what must be done with it upon conclusion of the trial.
I feel like a document that was funded by money that was taken from me, an organization that's supposed to represent me, and a video that features me, I should be able to do whatever I'd like with that video. I don't see why that would belong strictly to the sheriff's department.
Review it?
I'm sorry?
You said to review it?
I mean, I think I should have a copy that belongs to me.
I think there's any, one of the things that I do intend to do is have the video redacted as to anything that took place that doesn't have Mr. Hudson in view of the body cam.
So you're also trying to provide a redacted version of this?
Well, hold on, redacted for what purpose?
I mean, there's nothing exculpatory within the video. Mr. Hudson wants a video of the transaction occurrence for which he's subject to, or for which the charges stem from. So that's what the Commonwealth was intending to give him, was the dash cam that shows, I guess, the stop in the car, from my recollection, Officer Rose's body cam during the course of the interaction with the defendant during the course of the interactions in the car, or any conversations or actions that the defendant may have taken or said during the course of this transaction. But the Commonwealth had planned to redact it when it came to any private conversations that the officers had between themselves in the car and whatnot, away from the defendant. That's just what we had planned to do. There's no real rhyme or reason to it. It's just what we would do in this case.
And you would redact it, why?
I don't know. I mean, there's no real reason. It's just what we would do in relation to providing it. If the court so desires, I have no problem giving the whole thing. I just didn't see the evidentiary value in the private conversations that they had in the vehicle. But if the court says otherwise, I have no qualms giving it to them. There's nothing in there.
What's presented to the jury and what Mr. Mr. Hudson gets to see, I think, are two different things. So, I mean, there may be a valid reason for redacting tape, which simply means only showing part of it, if there's a valid legal reason. But I think he would be entitled to, if it's recorded, I think he would be entitled to see it, because it could potentially have other issues with regard to bias or anything else.
Well, we have no.
He's to see an unredacted version.
Okay, no problem with that.
Take it from there. So.
He even went so far as to call me a domestic terrorist who's a threat to officer safety.
We've got an individual who, I mean, I've noticed twice now that when the judge come in the courtroom, last time, this time, that he did not rise when the bailiff called everyone should rise. We've got an individual who says that he doesn't think the law in this case should apply to him because he wasn't there at its inception. So we've got an individual who, based upon the documentation, on his argumentation, thinks that the law is going to apply to him. So I don't think there's any prophylactic measure that the court could put in place to prevent him from taking these videos, altering and editing them. That's one of the reasons why we were so dead set on opposed to giving him copies of it. I mean, Judge, you know, we've addressed this before, but the notions and his notions or the ideologies expressed in his motions for whatever discovery, for lack of jurisdiction, lack of venue, while he says they have nothing to do with the sovereign citizen movement, they are almost mirroring several documents that were pulled from by the FBI from the sovereign citizen movement web pages, which does raise some concern in the mind of the Commonwealth as to officer safety. So, Judge, I mean, at this point, we're not obligated to give him anything pursuant to the Supreme Court of Virginia. And at this point, I don't think we're going to cooperate any further with him. I mean, he's already been here. I think this is the third or fourth time we've been here for this. At this point, I don't mind if the judge, obviously, if the judge so rules, I'll do whatever the judge says. I don't know if you want to look at it in camera before his motion to see if there's anything that motion to suppress, which is what we still have pending, to see if there's anything that the court wants to address. But at this point, he's not obligated, or we're not obligated to give him anything, and so the Commonwealth is opposed to it.
Even when their mighty judge ordered him to release the videos, they didn't want me to have a copy and only wanted to show me in their office a redacted copy. Not only that, they withheld Caleb Martin's video showing him shoo the library director away and only showed me the body cam of Luther Rose and Dante Robinson. I was able to obtain these videos via a simple FOIA request, but was met with great resistance via the discovery process. According to the Commonwealth's attorney, I'm just delusional here, and no violations have occurred. What do you think? Stay tuned for the next video where I expose the biggest bootlicking tow business I've ever seen. They literally advocate for a police state. Until next time.